My task this afternoon, for those who are not yet walking out, is to look at the issue of the distinction between moral objection and political dissent. Now, it is the case that a nation's decision to commit its resources to an armed conflict and to mandate the use of lethal force will always be controversial. For uniformed men and women, disagreement over when force is used and how it will be delivered has an intensely personal dimension because it touches on their moral integrity as well as their physical well-being. Now, although uniformed personnel remain citizens of the Commonwealth and participate in its common life, they are obliged to obey lawful direction from the government and to fulfil the task they are legally assigned. But they also overhear the party debates and observe the public protests. Being apolitical in the performance of one's professional work does not require political docility in one's personal outlook. I think the potential for dissonance is high and the potential for angst is real. Now, I would contend in all of this that uniformed personnel have rarely been properly prepared to handle the range of highly complex political and legal, ethical and moral issues arising from the operations to which they are committed. Foremost is a perennial failure to help uniformed personnel distinguish accurately between compelling moral objections and what I will refer to as routine political dissent. Now, this lack of clarity has complicated conversations and conclusions about where and why uniformed personnel might be justified in deciding to refuse service. And I would suggest that a poor working grasp of the just war tradition in both its classical and contemporary forms is largely to blame for confused conceptions about the moral status of an operation, a judgment that also applies to many parliamentarians and most pundits. The central challenge, I'm going to suggest, is moving from a focus on legal responsibilities and institutional regulations, which have focused on obligations and duties, to developing among uniformed personnel a capacity to reflect and an ability to reason so that soldiers can first differentiate between moral conviction and political dissent, second, to articulate and explain their position, and third, to canvass options and negotiate alternatives to actually refusing service. This movement needs to be accompanied by a number of things. Those things include a general acceptance that most deployments involve some controversy, whether moral or political, an acknowledgement that contemporary soldiers are better educated and more inquisitive than their forebears, a clearer articulation from political authority of why an operation is necessary and how it serves the national interest, and finally, a greater openness among uniformed leaders to actually openly discuss the issues and to address concerns. In relation to the last, can I say in the last 4 hours, I've become much more optimistic and positive about what I've heard and the quality of the conversation that we have had. Now, the present approach to deal quietly and confidentially with individual cases of conscientious objection is workable, but I think ultimately unsustainable. It is presently workable because these cases are few in number, while those involved usually prefer privacy and anonymity. I suspect many of you don't know that a previous serving VCDF asked not to be sent to a particular place where there was a conflict because that conflict was contrary to his own moral sense of what was a legitimate use of force. But I'm not sure that this approach will be adequate given the evolving weapons tactics scenarios and the corporate risk aversion that is associated with current and likely future operations. Australia's operating partners, all of them, have endured controversial courts-martial involving volunteers and conscientious objection over the last decade. We're the only ones that haven't had such a case. Nearest to home is the case of the Australian-born RAF medical officer, Malcolm Kendall Smith, who was imprisoned for 8 months, directed to pay £20,000 in costs, and discharged from the RAF after he refused to serve in Iraq because he believed the invasion and occupation were illegal and therefore immoral. Now, I think a large part of the present problem for this country arises from the unintended consequences of the Defence Act's recognition of a right of selective conscientious objection, also known as objection to particular wars, a provision that you might not know exists, but quite a few of your people might. Let me explain. In the original Defence Act of 1903, conscientious belief was defined as, and I quote, requiring a fundamental conviction of what is morally right and wrong, which is so compelling that the person is duty-bound to follow that belief. The Act recognised the validity of conscientious belief for those, and I quote again, who could prove that the doctrines of their religion forbade them to bear arms or perform military service, Section 60 of the Defence Act of 1903. Australia was in fact the first country to grant complete exemption from all military service on these grounds. Now, during the national service schemes of 1951 to 59 and 1965 to 72, total exemption from military service was granted on the basis of what was called deep-seated and compelling conscientious objection. No religious test being required after 1910. Now, conscientious objection was, it was said, always available to volunteers during peacetime. They could just resign. So they were protected. If you were a volunteer, you could seek administrative discharge. Now, in 1990, the Justice Minister, Senator Michael Tate, circulated the first draft of the Defence Legislation Amendments Bill. It included provision for the recognition of selective conscientious objection from particular wars, not all wars, but particular wars, for conscripts, although we hadn't had a conscript in the ADF for 17 years. The service chiefs in 1990 were mortified by the prospect of SCO being offered, even to conscripted personnel, because they contended that some of the principles that applied to conscript service could and would, and reasonably should, also apply to volunteer service, and this would lead to unhelpful confusion. Now, my knowledge of how at least one service chief felt was gained from being the speechwriter to the Chief of Naval Staff at the time. I also prepared the Navy's response to the draft bill. Now, these fears suddenly materialised when leading seaman Terence Jones failed to report to HMAS Adelaide before the ship deployed to the Gulf of Oman in August of 1990 to enforce United Nations sanctions against Iraq after its invasion of Kuwait. Now, leading seaman Jones defended his action by saying, while he was absent on leave, "I am not a coward, and I would be prepared to fight for my country, but I am taking a political stand because this is not our war. We are just following the Americans. I'm prepared to die to defend my country, but not to protect the United States oil lines." Now, he inferred that it was moral to be political in this instance. Now, although the Defence Legislation Amendments Bill was still in draft form when Jones was declared absent without leave, the independent and former Nuclear Disarmament Party Senator for Western Australia, Joe Valentine, introduced a private bill into the Senate, really helpful at that moment, but put that to one side, for an act relating to conscientious objection to certain defence service. She praised leading seaman Jones for being aware, informed and intelligent. What did that say about everybody else in the ADF? Well, that Jones was taking a political stand that Valentine sought to protect as a matter of conscience was very interesting. The inference was that a person's political beliefs were part of their moral conscience and therefore worthy of special protection. Now, at his subsequent court-martial, because it was always going to end in tears, Jones was found guilty of being absent from his lawful place of duty without approved leave. He was sentenced to 21 days detention, reduction in rank to able seaman and forfeiture of 4 days' pay. Jones then sought, surprisingly, discharge at own request. Now, despite the severity of the punishment, which was intended to make an example of Jones and to highlight the operational seriousness of his untimely abstention, he was the only person in that ship who did his job, and the Navy still remembered when a certain pilot on board HMS Invincible was brought back to Australia because he wasn't able to stay in Invincible for the Falklands War, and the person who replaced him without a workup died in a mid-air collision 3 weeks after he replaced him. So the importance of having worked up people in worked up teams going to operational zones. The Navy's view was that Jones really deserved much of what he got. And a confidential paper prepared within the Naval Support Command shortly after the court-martial noted, and I quote, "In practice, a considerable degree of flexibility has been shown in attempting to accommodate personnel who have genuine difficulties in participating in particular operations. This flexibility was exercised in the Gulf deployment where commanding officers agreed to allow a number of people to post off ships for a variety of reasons, some less compelling than conscientious objection. The ability for commanders to do this is obviously useful and should be retained," said the Navy, "provided it is not seen as a de facto right of conscientious objection on the part of the individuals concerned." Well, how are you going to prevent that from happening? But there it was. Now, Jones's court-martial prompted an inquiry by the Human Rights and Equal Opportunities Commission, whose commissioner, Brian Burdekin, was concerned that the absence of any right of selective conscientious objection offended against the spirit of his commission's Act of Parliament and appeared to be contrary to the International Covenant on Civil and Political Rights, which was incorporated into Australian law by the Heriock Act. In reply, the ADF insisted, and I quote, "An expectation that all lawful orders will be obeyed is fundamental to the maintenance of discipline. Concomitant with this expectation, there must exist a right to take disciplinary action when breaches of this fundamental obligation occur. In other words, the right to enforce the obligation to serve is reasonable and is not discriminatory. Accordingly, so far as volunteers are concerned, there is no scope for allowing for conscientious objection with respect to specified operations or indeed combat generally, unless the matter is raised as a ground for discharge at own request." The trouble was people knew that SCO was being recognised quietly and confidentially. Well, at least I'll say that was the case in the Navy. And when people overheard that, they thought somehow there was a de facto, quiet, informal, call it what you like, readiness to recognise that sort of objection. Now, I observed that that the desire for the recognition of conscience became a hot issue again before the planned invasions of Afghanistan in 2001 and Iraq in 2003. Now, both operations, we know, provoked a great deal of discussion about the justification of Australian participation, given the absence of any clear, ambiguous, immediate or direct threat to the Australian people and the national interest by either Afghanistan or Iraq. It was a case of connecting up the dots, but it wasn't directly obvious that those two countries and what happened within them would constitute a threat to Australia. Now, in trips around the country at this time to units and bases when I was the Anglican bishop to the Defence Force, I heard laments and complaints about both operations and detected that many previously apolitical servicemen and women felt they and their skills had been used for domestic political advantage and the generation of international goodwill. I spoke at a forum at RAF Base Tyndall on military ethics and shut it down after 25 minutes because I thought half the warrant officers were getting close to sedition. That's how strongly many of them felt. They felt that what was happening in the Middle East was far removed from defending Australia and its national interests. Matters of conscience and the nature of obligation were at the forefront of conversation. Now, based on my observations then and now, I would contend that the vast majority of ADF members have not actually thought much about the difference between moral objections and political dissent, and the majority do not know how to differentiate between them, and even fewer have thought about what they would do if confronted by a moral objection within their service. They kind of hope that it won't happen and assume that that will be their experience by and large. But let me develop my argument with some brief definitions. I understand to be moral objection to arise from personal convictions about right and wrong. Now, convictions are stronger than beliefs in that they embody firm conclusions that must be honoured because they are part of a person's identity and cannot be violated without damaging a person's integrity. Any person is entitled to refuse to participate in any action that adversely affects their identity or their integrity. And the Defence Act puts it this way: a conscientious objection is so compelling in character that the person is duty-bound to espouse it and it is likely to be of a long-standing nature. The view comprises who they are. Conversely, political opposition is an expression of individual disagreement based on beliefs about possibilities and preferences. These beliefs are essentially opinions or judgments with respect to competing courses of action. Political dissent is disagreement with a government decision or policy on practical grounds, such as, say, economy or efficiency. The tradition in a liberal democratic society is to protect conscience by respecting moral objection and seeking to accommodate its demands in some way, and accommodating its demands in some way, while treating political dissent, which is usually considered a matter of opinion, best managed through parliamentary processes and the ballot box. Now, I would argue that public discourse has tended to give such dissent a standing that it does not deserve. Since I joined the ADF 37 years ago, I've noticed a very substantial shift towards respect for personal convictions of all kinds. The ADF has been liberalised as the host society has. For the greatest part, this shift is welcome, but conceptual challenges remain. I would contend that the two most pressing challenges are explaining the distinction between objection and opposition, and ensuring that moral conversation is not prescribed as an incitement to mutiny. Trying to pursue mission objectives with both effectiveness and efficiency while giving conscience due regard is not always easy or straightforward. And I realise there is impatience with suspected or declared conscientious objection among volunteers. An impatience reflected in the retort, well, if they don't approve, they can leave. But I would respond to that in two ways. First, what if the objection is valid because the planned action is morally objectionable? The presence of conscientious reflection in a unit may be crucial to preventing immoral and potentially illegal behaviour. Second, should a career be ended because a person thinks that their participation in one activity is incompatible with their moral conscience and seeks an alternative? Does that then render them incapable or the wrong kind of person to render service at all in the ADF? But the pressing issue, I think, is not so much respect for conscience, but differentiating morals from politics. I've met many people claiming to profess a moral objection when their position is no more than political dissent. They think that something is bad, by which they mean a poor option, rather than wrong, by which they mean defying a principle. And so to help soldiers better understand the issues and to differentiate between objection and dissent, I believe the Army does need to invest more in ethics education and training, and perhaps to engage the assistance of the university and the expertise that it brings in philosophy and sociology. So let me close with some practical proposals to that end. My first proposal is that much of the language used in discussions about the character of armed conflict is loose, undisciplined and lacking in precision. There is scope for a small handbook to be produced that distills the consensus that now exists among philosophers and social theorists about what words mean when they're used in particular contexts. Second, I think that initial entry training and continuing education programs need to be augmented with an aid memoir that covers the legislative dimensions of service and the ADF's commitment to conscience, so that every person is aware of expectations and entitlements, so they do not think as a volunteer that they are entitled to conscientious objection when they are not. And third, given that the just war tradition shapes most ethical reflection on armed conflict in the Australian context, and that such thinking is dynamic rather than static, and because the conduct of armed conflict is forever changing, I think there would be merit in the Army convening an annual round table focused on connecting practical developments with emerging insights drawn from the previous 12 months of just looking around the world, and the round table resulting in an annual review for distribution among leaders and trainers and operators. How is the just war tradition serving the context of modern armed conflict? Fourth, I think there is a need for regular consultations that consider changes to community attitudes to individual rights and entitlements and the ADF's priorities and objectives. We don't want there to be a big gulf between the community and the uniform community so that one neither understands the other. To focus on the former without any cognizance of the latter will work against achieving any practical progress in the direction of enhanced respect for moral integrity, which I would say separately is a way of avoiding moral injury. At the moment, a mission-minded ADF is occasionally constrained from seeing the importance of being morally minded as well, but much progress has been made. And fifth, while there is merit in lawyers turning their minds to the shape of future legislation bearing upon the recognition of conscience, I believe there's scope for a group of like-minded military ethicists to produce an equivalent of an explanatory memorandum that comes before the legislation proper, that succinctly sets out the need for such legislation, the principles upon which it is grounded, the values it seeks to promote, and the objects for which it strives. The first thing that I would suggest is repeal of the current section of with respect to selective conscientious objection, remove it out completely, because remaining there in the context of conscripts, I think, is leading to, at least from what I detect when I speak to people, some confusion. These initiatives would signal the importance that the Army attaches to matters of conscience, and also, I think, indicates the extent to which the confusion of moral objection with political dissent is unhelpful, and that the Army is not faced with missions disrupted by needless debates that have the capacity to damage morale and diminish cohesion. These initiatives are best advanced when questions of morals are not the sport of politics. Let me now pause and take your questions and comments. Thank you.
How common is this in our APCA community countries of like origin, like legal origin?
Of matters of selective conscientious objection? From what I pick up, they're probably in the handfuls of cases. They're not large. I think there would be very few if, for instance, people would pull apart some of the issues. The Bergdahl case in the US is an interesting one, where the language that he's used is more the language of politics, say, than questions of morals. I think perhaps if I'm picking up from friends in the UK a sense from them that it's perhaps most plaguing the British Armed Forces, less perhaps though with ours, and that's why they've gone towards a direction of a covenant, which I've spoken about at another conference recently. The Canadians seem to have the issue as well. Again, it's hard to know because it's all dealt with unofficially, the extent to which people are seeking this kind of relief. But we are wanting to do a project we've done a theoretical project on moral injury, getting to the point of wanting to do some field work, and it's difficult in Australia. The Canadians have decided not to head in that particular direction because of legal constraints, but also reputational damage. Now, I gather from them that they've had many instances in the last decade where people have said, because they've looked at Canada's Bill of Rights and said there are certain things I can't do, and applied that into the context of their service. So other than people that have tried to make, if you like, a cause celeb of themselves by court-martial me, I want this to be public, I'm thinking that there's handfuls of cases in each of those places, and that people would rather deal with it privately because they don't want to be the subject of controversy and things like that. That's my feeling of it. If we had a case coming up in the future, I mean, we've had people who've been volunteers, resigned and then made political statements. They've not tried to retain their membership of the ADF and then make those kinds of remarks. So I think I'm partly dealing with a problem or an issue that we don't know the extent of it. We may not want to know the extent of it, but certainly I think it hasn't had the currency in conversation that it deserves, given its ability to corrode unit morale. Neil James.
Tom, Neil James from the Australia Defence Association. My job involves me working in the politico-military interface fairly dramatically. And my observation would be that with social media and the way our politics is working, and with what you'd loosely call the loss of religious faith across Australian society, the ability of people to choose, in your terminology, between what is a bad policy and what is wrong morally is in really serious trouble, because the average Australian, and particularly the average activist voter, seems to think, particularly on the extreme left of politics, but to an extent on the extreme right, that their position is based wholly in morals. And the moral vanity of, say, a lot of people who vote Green is absolutely breathtaking to face.
I'll take that as a political statement now.
Well, no. Well, you know the ADA is pretty apolitical. We work with all sides, including the Greens.
And your question was?
Well, the question really is how in modern Australian society, when the average Australian can't tell the difference between what's bad policy and what's a moral issue, and they no longer have any religious background to allow them to make that type of decision, and a lot of young people these days believe in situational ethics rather than anything more steadfast in their character or their soul. How do we face this problem? It's just going to get worse. It's not going to get better.
Well, I don't know that so much the problem gets worse. The challenge for the Army becomes greater, because the Army has to take whoever decides to put up their hand and volunteer and turn those people into effective uniformed personnel. I must say I'm much encouraged by the richness of the language that Ian Langford was using, as to say, look, we need to induct people into a new way of thinking, a deeper way of thinking with more textured language, so that wherever they've come from and they've joined for whatever reasons, they're not so much programmable, but I do think it's the case that they can be shaped, they can be moulded to be part of a team which has certain values and virtues, and if they choose to have them, that's great, they'll stay. If they don't, they then will leave. I think what you're pointing to, Neil, is just a case of the gulf between the kinds of people we want in the ADF and what the country might be supplying could be getting greater, or at least that the average person is not dealing with the kind of complex issues that are being dealt with by Army people. And therefore, that just means there's a greater training and education burden to better prepare them for that. When you look at what we did for people that went to Gallipoli a century ago, or how we didn't prepare them, and you look at the discourse, the way they thought about what they were doing, it wasn't particularly sophisticated. Now, it seems to me, it is, and therefore, I think the Army's intellectual culture, which does allow people to talk, and if you want to talk about an operation, it's not seditious and it won't end up necessarily in a charge of mutiny, I think that is good. Managing it and keeping it, though, making it productive, I think that's another element of the challenge. I just do feel that the raw material that the Army gets perhaps requires more shaping than ever before. And I think that's just the reality that we face in that regard.
Yep. Hugh Smith, UNSW Canberra. Thanks, Tom, for a very stimulating presentation. Let me try and muddy the waters a little. Firstly, I think the attempt to draw a very clear, bright line between politics and morality is unwise. Politics does have elements of morality in it, and morality has elements of politics or society in it. And where I think leading Seaman Jones went wrong was saying that he was taking a political stand. If he'd said instead, I'm taking a stand on just war principles, this is not a war of self-defence, etc., he might have been viewed very differently. That's one area. The other thing where I think there's uncertainty is the question, what are people objecting to when they exercise conscientious objection? Is it to a whole war? Is it to a particular campaign? Is it to the use of certain types of weapons? And I think all of those, and lots of other objections, particular objections, all of those require a fairly nuanced consideration. I'm trying to think of a parallel in the community. Maybe it's something like euthanasia, where things are so difficult to put into law and clear principles that we let it go on and trust to the common sense of medical practitioners and others. So should we even try and draw such distinctions in this context?
Well, I think that my view is that language is all over the place. People don't know how to use it properly. And I had a fairly unseemly stoush at a conference in Queensland where Judy Davis, the actress, had said that the war, if we were to go into Iraq, it would be immoral, and the article was like this. And I criticised the article at this conference, and the then Labor Foreign Affairs spokesman, one Kevin Rudd, kind of kept on pressing the button. I went to intervene, and he thought that I was suggesting that all objection to the war was lining up with Judy Davis. But it was simply that I think that she was claiming for her views, which were everything connecting with free trade agreements and things like that, were to impart to her views a kind of sanctity, if you like, that they didn't observe. They're just straight what I was hearing was just straight political discussion. And then what I got from him was the same stuff. Like when he says, take Kevin Rudd as an example, climate change is a great moral challenge of our kind of whatever, without saying what he means by morals. So I take your point about when someone morally objects, what are they objecting to and what makes it a moral thing? And I'm suggesting that that's not kind of so well known, and that's probably why some people face some difficulties when they need not. I think I need to stop to exercise the... Okay, George.
Thank you.
George Georgiadis.
Tom, what do we do to help an individual reconcile when there's a schism in his own belief system where his loyalty to his unit, friend and team is in conflict with their conscience for a particular activity? How do we help them reconcile that?
I think it's straightforward. They have to be true to themselves, and that's it. Because in the end, people they live with themselves longer than they live in a green suit. And therefore, it seems to me, the longevity of their own personal integrity is more significant. Well, I've said this to everyone, from policemen to prison officers, that if you can't look at yourself in the mirror after you do whatever it is you do and find someone that's something admirable or that can be respected in what's looking back at you, then you shouldn't do the thing. I mean, in the end, you're going to leave the army, you'll be someone else, and maybe you'll say, oh, I did those things as a compromise in order to continue serving and things like that.
But if their strength is so strong for their loyalty as opposed to their conscience, you're asking them to choose one over the other.
Well, you can't ask them to act contrary to conscience, George. I couldn't do that in good conscience to anyone. If someone's conscience dictates certain things, that's more significant about who they are than the fact that they're a member of the army for the time that they're in. It may be really hard, and I've talked about why should someone with a moral objection have to go. But if you have no choice and you have to do something that you think is wrong, my advice would be don't do it, because you live with someone that eventually you won't like. At that point, I'll stop and I'll invite you